Start. The appellant Bogai Buri has been convicted under section 109/302 of the Indian Penal Code and sentenced to undergo rigorous imprisonment for life with fine and default stipulations for the death of Muhammad Hussain alias Farooq. Three other persons were jointly tried for the murder of Muhammad Hussain and convicted under section 302/34 IPC and also sentenced to suffer rigorous imprisonment for life. The prosecution case is that on 8/7/2010 in between 4:30 to 6 p.m. Muhammad Hussain alias Farooq of Dakhin Hengera Tea Estate was assaulted by the three other co-accused at the instance of the appellant by means of sharp objects. The place of occurrence was beside the road of line number 6 of the tea estate, where the mutilated body of Muhammad Hussain was found in a ditch. Izahar dated 10/7/2010 came to be lodged by Muhammad Rohimuddin Ali (PW2 who is the son of the deceased, and the same was registered as Golaghat PS case number 348/2010 under section 302 IPC. In course of investigation, the appellant along with the other three accused were arrested, and upon completion of investigation, charge sheet was submitted for committing offence under sections 341/302/109/34 IPC. The case was committed to trial. The prosecution examined as many as 12 witnesses, including the medical officer and the investigating officer. The appellant was examined under section 313 CRPC and was also heard on the point of sentence. Medical evidence brought on record disclosed 6 incised wounds on the neck, lower back, buttock, etc. on the person of Muhammad Hussain alias Farooq. In the opinion of Dr. Sayyid Sajadur Rahman (PW4) death was due to hemorrhage and shock as a result of cut injuries caused by sharp weapon. Conviction of the appellant is primarily on the confessional statements made by the other three co-accused before Ankur Bhuyan (PW8), who at the relevant time was serving as judicial magistrate (first class) at Golaghat. The names of the other three co-accused are Rantu Mahili, Dukhiya Karmakar and Saharu Orang as recorded by the court below. There is no direct evidence against the appellant save and except the confessions made by the three co-accused mentioned above. To what extent the confessional statements marked as extension 7, extension 8 and extension 9 can be made the basis for convicting the appellant, having regard to the scope of section 30 of the Evidence Act as well as the law laid down by the apex court on the issue involved, is the primary point for determination in this appeal. From the materials on record, there is no doubt that the confessional statements of Rantu Mahili, Dukhiya Karmakar and Saharu Orang had been recorded observing the required formalities under section 164 CRPC. The contents of the confessional statements made by the three accused persons above are predominantly the same, where each of them have confessed to the murder of Farooq on having been tempted by the appellant that they will be given a sum of rupees 15,000. However, the promised money was not paid. For better appreciation, the confessional statements of Rantu Mahili, Dukhiya Karmakar and Saharu Orang are reproduced here under. No doubt, the confessional statements have also implicated the maker substantially to the same extent as done against the appellant. The question therefore is to what extent the confession made by the co-accused persons can play in a criminal trial in the light of the provisions under Section 30 of the Evidence Act. Section 30 of the Evidence Act provides that when more persons than one are being tried jointly for the same offense and a confession made by one of such persons implicating himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes all such confession. What is discernible from the provision of section 30 is that it merely enables the court to take the confession into account, and how it is to be done have received consideration in various judicial decisions. A confession cannot be treated as evidence which is substantive evidence against a co-accused person. Para. A constitution bench of the apex court in the case of Haricharan Kurmi versus State of Bihar reported in AIR 1964 SC 1184 have held that in a criminal case where the prosecution relies upon the confession of one accused dash person against other accused dash person, the proper approach to be adopted is to first consider the other evidence against such accused dash person, and if the said evidence appears to be satisfactory and the court is inclined to hold that the said evidence may sustain the charge framed against the said accused dash person, the court would turn to the confession to assure itself. Full stop. Over.